We're live, Madam Chair.
All right, welcome everyone. Today is I'm calling to order the Minnesota Sentencing Guidelines Commission. Today is February 12th, 2026. Are you doing the roll? All right, and we're going to ask Linda McBrayer to take the roll for the commission.
Thank you, Chair Mitchell. Calling the roll, Commissioner Castro.
Present.
Commissioner Eid. Commissioner Eid. Commissioner Fraze.
Present.
Commissioner Fraze, present. Commissioner Keefe. Commissioner Keefe, absent. Commissioner Ladd. Present. Commissioner Ladd, present. Commissioner Mazzaros, we know that he's absent. Commissioner Middlebrook. Present. Commissioner Middlebrook, present. Commissioner Moore.
Present.
Commissioner Moore, present. Commissioner Morin. Commissioner Morin, absent. Commissioner Mueller.
Present.
Commissioner Mueller, present. Commissioner Reeves.
Present.
Commissioner Reeves, present. And Commissioner Saxena. Commissioner Saxena, absent. Chair Mitchell.
I'm here.
Chair Mitchell, present.
And then do you want to recall Commissioner Keefe?
Commissioner Keefe. Madam Chair, if I did this correctly, there are 9 members present, 4 members absent.
Great, we do have a quorum. Thank you. First, can we recall Commissioner Eid?
Commissioner Eid.
Present.
Commissioner Eid, present. Madam Chair, we now have. Okay, we're good.
10 present. We do have a quorum.
Yes.
Excellent. All right. Next, first item on the agenda is approval of the agenda. So I would entertain a motion to approve the agenda.
So moved.
Commissioner Reeves makes the motion. Do we have a second? Commissioner Moore seconds. Any discussion on the agenda? Hearing none, we'll go ahead and call the roll for that.
To the Reeves motion to approve the agenda, Commissioner Castro,
Yes.
Commissioner Eid,
Yes.
Commissioner Eid, yes. Commissioner Fraze,
Yes.
Commissioner Fraze, yes. Commissioner Keefe? Yes. Commissioner Keefe, yes. Commissioner Ladd? Yes. Commissioner Ladd, yes. Commissioner Mazzaros? Commissioner Mazzaros is absent. Commissioner Middlebrook?
Yes.
Commissioner Middlebrook, yes. Commissioner Moore?
Yes.
Commissioner Moore, yes. Commissioner Morin is absent. Commissioner Mueller?
Yes.
Commissioner Mueller, yes. Commissioner Reeves?
Yes.
Commissioner Reeves, yes. Commissioner Saxena? Commissioner Saxena is absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. The count is 10 yes, 3 absent.
And with that, the motion is approved. Next on the agenda is approval of the draft meeting minutes from January 8th, 2026. You should have received those last week. I would entertain a motion to approve the minutes.
So moved.
Commissioner Castro moves. Commissioner, I forgot, I'll say Middlebrook seconds because I know that for sure. Any discussion on the motion? Hearing none, we'll go ahead and call the roll.
To Commissioner Castro's, approve the minutes, excuse me, Commissioner Castro.
Yes.
Thank you. Commissioner Eid.
Yes.
Commissioner Eid, yes. Commissioner Fraze.
Yes.
Commissioner Fraze, yes. Commissioner Keefe. Commissioner Keefe, yes. Commissioner Ladd. Yes. Commissioner Ladd, yes. Commissioner Mazzaros, absent. Commissioner Middlebrook.
Yes.
Commissioner Middlebrook, yes. Commissioner Moore. Commissioner Moore, yes. Commissioner Morin. Commissioner Morin, absent. Commissioner Mueller.
Yes.
Thank you. Commissioner Mueller, yes. Commissioner Reeves.
Yes.
Commissioner Reeves, yes. Commissioner Saxena, absent. Chair Mitchell.
Yes.
Madam Chair, there are 10 yes votes and 3 absences.
And with that, the motion is approved. All right, thank you. So the goal today is to put a little more flesh on the bones of the couple of the topics that we'll be taking up during 2026. So the first topic area that we're going to talk about is Hernandizing, and we'll tackle that from 2 directions. We've got the staff who will be presenting some data for us, and then Professor Reitz is also here to talk to us about some of the research that they've done on this over at the University of Minnesota. So we're going to have Matt Hilna step up, and he will go ahead and present some quick facts, some data for us.
Thank you. We're going to start first with Linda providing some information about just how Hernandizing works.
In a much more comfortable role than my previous one here.
And then we'll get into some of the data surrounding Hernandizing practices in the state. I'm going to grab my water bottle real quick.
So we're often asked, what is Hernandizing? And basically it is an unofficial term because it comes from a state of Minnesota court case, State v. Hernandez. And that case upheld the idea that is found in the first part of the guidelines under section 2B1 that says, count everything that has received an imposed sentence or stay of imposition prior to sentencing on the current offense. So what the Hernandez case did was explain what before meant. And so before will literally mean sentence number 1 will be Hernandized onto sentence number 2. So this is a situation when multiple offenses are going to be sentenced in a single hearing. And how do we count criminal history when we normally think of prior history as the history before they even got in the courtroom? So now we're talking about those multiple offenses being sentenced in the same hearing. One thing that the commission does not address is the idea of single course of conduct versus separate course of conduct. So we have 2 exceptions to the policy, but in general, it looks like this. We have sentence number 1 is a theft offense. And you can see that that person has 4 criminal history points. We go on to sentence number 2. And we see now they have increased that by adding the theft onto the drug offense. And then in this case, the person had a 3rd sentence imposed on a possession of firearm, which allowed, sorry about that, which allowed the theft and the drugs to be Hernandized. So that's the basic concept behind Hernandizing. And when we're working with practitioners, we often place more emphasis on the exceptions to the policy because in general, when there are more than 2 offenses that are being sentenced, we will Hernandize. But the first exception that we have is entitled a single course of conduct, multiple sentences. And where we want to be very careful with this is the idea of what multiple sentences means. It's specific to 3 offenses only that we apply this exception. So when one of the offenses is a burglary, a kidnapping, or meth or fentanyl involving a child or a vulnerable adult, and another offense is committed as a part of that act, both offenses can be sentenced. There are double jeopardy statutes for both kidnapping and burglary. And then within the methamphetamine offense, there is a statute explaining conviction of this offense is not a bar to conviction for any other offense that occurs as a result. of this crime. And that's kind of an important statement to remember because that does appear in other places in statute, but this is where the commission has applied that idea that the earlier offense, meaning sentence 1 in this case, is not going to be Hernandized onto sentence number 2. So we have a burglary and a theft offense here. And you can see that they have the identical criminal history, even though they have both received an imposed sentence, even though they may both be eligible for things like consecutive sentencing. So despite the fact that the criminal history score doesn't go up, there is still that imposed sentence. This policy continues on to the future when they come back into court with this in their history. The commission says only take 1 at the highest severity level. So for this person, it would probably read burglary/theft on their criminal history worksheet, only providing 1 point for both of those offenses. The second exception to the rule is called a single course of conduct, multiple victims. This is a little more straightforward, and we often work with practitioners on this when we have an aggravated robbery or a criminal vehicular type offense. And in these situations, what the commission does is not limit the number of offenses that can be sentenced in the event, but rather how they will be Hernandized. So the commission has said we will only include 2 at the highest severity level as we move through the course of events. And then we continue on that same idea when someone comes into court on a new offense and these are being included as a prior, we only take 2 of them, regardless of how many sentences the person received at the time. Their criminal history score is not going to go up drastically because, again, we're only including 2 of them. So here we have several worksheets that indicate a very common one, which is a aggravated robbery. They come in with no criminal history. When we look at the second worksheet, we can see that the first offense was Hernandized, and we'll see that same thing on the third offense. That is, in a nutshell, what Hernandizing normally looks like. So it is not until we add that fourth offense that we see the policy come to fruition, where despite having 3 prior offenses that we could include, only 2 of them have been counted at the highest severity level. So that is the end of the explanation of what Hernandizing is, and I'm happy to take any questions before turning it over to Matt for the data.
Any questions from commission members? Looks like Commissioner Mueller has a question.
Thank you. I'm curious on if I could get some insight into the sentencing. So maybe it appeared just in some of the notes that this sentencing multiple offenses at the same time was done just out of efficiency. Is that the case, or is it? I'm curious about that a little bit.
Yes, sir. Yes, Commissioner Mueller. That is the statement that the district court, or the appellate court, excuse me, actually put in to the Hernandizing case, which was that the district court was doing, in essence, saving the court time by sentencing all of them at the same time, as opposed to coming in on different days. So it was a matter of judicial economy, as they put it, to bring all of these offenses in. And these can be offenses that were committed at the same time or over a period of time. It's just the finalization of them, the sentencing of them, where they bring it all together. Does that?
Thank you.
Okay.
Commissioner Castro.
I'm so sorry.
So I'm a little confused by that. Generally what happens is because they're all charged on the same complaint. Not because they're separate complaints on one course of conduct.
Mhm.
So if they're all charged on the same complaint, how will we bring them back? I mean, we would sentence them all at the same time.
That stands to reason, yes. So really where this becomes an issue is when it is not one of the burglary, kidnapping, or methamphetamine offenses, but just multiple offenses where they're all being sentenced at the same time for whatever reason that the court has to do that and to Hernandez them. So I think the issue that practitioners, which is mainly what I focus on, struggle with is that idea of single versus separate. But you're absolutely right. A single complaint with multiple offenses should come into court at one time, but we're one step back from that and just looking at what happens after all of that has been decided and now they're going to be sentenced.
I think partly what she's saying, Commissioner Castro, is that I don't know if there's a lot of distinction in the case law between those two different situations where you might have one complaint with multiple counts on it versus somebody who committed a couple of crimes at different times that could be sentenced over multiple sentencing event hearings, but may have been brought into one hearing to be sentenced all at once, because that happens too.
Right, but then that wouldn't be a single course of conduct.
Correct. And I don't think the case law distinguishes between those two things
Okay.
on this point.
Thank you. Matt, my colleague, will show you the data related to Hernandezing.
Great. So Hernandezing in practice. The first thing I wanted to bring your attention to was that the number of Hernandez cases has increased, but that's also along with the number of cases sentenced in general increasing. So that first figure on the left, the dark blue line on the bottom is the number of Hernandez cases. And then the green line up top is the number of total cases. So you can see both of those have increased over time. The thing that is more important to note here is that the percentage of all cases that have been Hernandez, or the percentage of all cases that are being Hernandezed has increased over time as well, right? So not only has the number gone up, but the percentage of all cases that are sentenced throughout Minnesota throughout the entire year, the percentage of those that are being Hernandezed has increased from about just under 20% back in 2001 to over 25% now. Something to note about this figure on the right is that there is a bit of a spike between or right after 2020, which is not surprising, having the backlog of cases to work through for sentencing over the next couple of years. And you can see after 2022, those cases start to, the percentage of cases that are being Hernandezed starts to decrease again. So we see that jump that is probably a little bit erroneous due to the COVID pandemic. But nonetheless, you can still see that there has been an increased percentage of cases Hernandezed over time, even if you take out this section right here.
Commissioner E.
So is it to Judge Castro's or Commissioner Castro's question, that spike, is it attributable to, or do you know, if it's attributable to multiple complaints because of the backlog being resolved in a single hearing, or complaints being charged with many offenses getting resolved? Or do you think it's more likely the former because there was a backlog and people that were being Hernandez had collected a number of different complaints, and so that's what was happening?
Right. Yeah. So I don't know for sure. I'm not positive for sure, but I would say the former is my hypothesis. Yeah, just this backlog of cases being sentenced. But that's certainly something that we can look into and get a definitive answer on during when the committee for Hernandezing is put together.
I mean, the only follow-up I would just would
Yeah.
add to that is I think from a district court judge's perspective, it doesn't seem like you would most commonly think of a multiple complaint sentencing situation as a traditional Hernandezing situation, because if those complaints had just been naturally resolved at a different period of time, the previous complaint would of course be considered in the criminal history.
Sure.
I think that the traditional Hernandezing scenario, right, is when it's multiple offenses and a single complaint that's moving someone across the grid, right? Well, I don't know if that's what the basis of your confusion was, Commissioner Castro.
No, it is, because I mean, it seems to me that if you have multiple complaints, you don't have a single course of conduct. Well, I guess what's confusing, and I guess I've never known this to be the case, that prosecutors would file separate complaints. Let's take aggravated robberies. One night, you know, if somebody goes out and decides to rob 4 people, goes from, you know, corner to corner to corner to corner. I mean, one prosecutor would charge those out in one complaint, right? And then under that case, I would have to use the Hernandez method and not increase that last sentence, assuming they'd all plead guilty. And in another case, if they're separate complaints that are in front of 4 different separate judges and come to sentencing at 4 different times, that 4th case would get the points from the previous cases.
Yes.
And that fundamentally is what we're trying to fix or adjust or remedy.
No, we're just trying to look at Hernandezing in general. There are some inconsistencies, like, I mean, that's one of them,
Okay.
right? But there's multiple inconsistencies, and we'll sort of get some of those issues on the table as we continue to go today.
Okay.
Thanks.
The next slide discusses the most common Hernandez offenses. And by most common, I'm talking about 2 separate things here. So if we look at this table, first, the first column is the offense name. The second column is the just total of cases that were Hernandezed. And then the third column is the percentage of all cases sentenced for that offense that were Hernandezed. So for this top part, controlled substance 5 offenses were the most, had the highest number of cases that were Hernandezed. However, only 25% of all cases that were sentenced for controlled substance 5 were Hernandezed, right? So we know controlled substance 5 is one of the most common offenses sentenced in the state. So it's not too surprising that this is also the highest, the offense with the most raw number of cases Hernandezed. The second portion, I provided the highest percentage of cases Hernandezed, right? And so these should also be probably a little bit expected, that these cases are the most frequently Hernandezed. While they're not the highest numbers, they just are Hernandezed more often when they come to be sentenced. So possession or dissemination of child sex abuse material is the offense that has the highest percentage of all cases sentenced being Hernandezed. Then we have tax offenses, check forgery, right? So these are offenses that if you're doing it once, you're probably doing it multiple times. It's usually not just a one-off. Any questions on that slide?
Just that, is this data collected after 5th degree, certain 5th degrees became gross misdemeanors?
Yes, right.
Okay.
So this is including data from 2020 to 2024, right? So the misdemeanors, I think, are probably falling off there, right? If we're just talking about felonies after the TSRA. Yeah, TSRA.
Thank you.
Yep. This next slide is the proportion of cases that have the proportion of priors within each Hernandezed case, right? So if we look at 2001, 70.9% of cases that were Hernandezed only had 1 prior Hernandezed. Does that make sense? Right? Now, if we look at 2013, it goes down to 64.5%, had only 1. And then in 2024, we're now at 59.3%. So what this figure is essentially telling us is that the number of cases that are being Hernandezed, the number of priors is increasing for cases that are being Hernandezed over time, right? So whether that's across all other sections of this, of each bar chart here, right? So the, in the green, that's 2 priors Hernandezed, right? You can see that those numbers are increasing from left to right. If you look at 3 priors Hernandez, those numbers are increasing. So it's increasing across the board for each of these sections. And just in general, the consensus takeaway for this, or the overall takeaway for this slide is that not only are Hernandez or cases being Hernandez more often, but also the number of priors that are being Hernandezed is increasing. If that makes sense.
Is that like within a single event, like that at the time that Hernandezing is happening, that there's more,
Yes, the number of, yes, exactly. The number of, yes, if I'm understanding right, like in this case, 2 priors are being Hernandezed rather than someone having 2 priors. Am I answering that question?
so like
correctly?
if they came in before, so in 2001, if they came in with a case,
Yeah,
most of those would maybe have 2 counts on them because they're just Hernandezing one onto it.
mhm,
But in 2024, they come in and now more of those cases maybe have 3 counts on them
Exactly.
and they're Hernandezing 2
precisely.
in that
yes.
event instead of
Well said.
1. Okay,
Yes, thank you.
thanks. Just want to make sure I understood.
Yeah, that's great. That was really, really well said. Thank you. Any questions here?
So just so I can clarify.
Yeah.
All of the data we're looking at could include the situation of multiple complaints, right?
Yes.
And is it possible to break that out?
That,
Where it's like to look at just single complaint Hernandezing?
I think that's something we'll have to discuss. I see the utility behind that, certainly, yeah.
But yeah, I don't know. It just seems to me they're not necessarily the same thing.
Definitely, yeah. I see what you're saying.
I don't know if this is a thing to answer now, but I'm curious about the Clean Slate Act and how that's gonna impact. And the Clean Slate Act is like basically folks not having access to the history of priors. So I don't know. I'm just curious about that.
Hmm.
And what this will look like.
Sure.
It shouldn't, I would say it shouldn't affect this because what's happening here is you're coming in to be sentenced with new offenses. And so you have multiple offenses on the day you are being sentenced. And it's just, this is a rule for how we determine what criminal history is going to apply to each one of those offenses that you're being sentenced on that day. So clean slate would only affect anything that might have occurred
In the past.
before that sentencing offense and that might have been sealed. Like that just wouldn't be included in the criminal
History
history.
score. Okay.
If I'm getting my clean slate law right, which I think
You know
so.
more than me.
Madam Chair,
Oh, go ahead, Director Wrights.
yeah, I mean, that's a really interesting question. I don't know that it's related to this issue in particular, but the whole issue of how expunged records can or cannot be used in criminal history is a really interesting one. And the general rule is, as currently stated in a guidelines comment, is that even expunged records can be used in criminal history. And that's something that's provided for in statute, with one exception that I know of that probably wouldn't have any impact in criminal history anyway. But that is an open question for the commission as to whether it wants to revisit that policy and whether it wants to consider expunged records in criminal history.
Sweet. Any other questions on this slide? Terrific. Now we come to the topic of being pushed over the dispositional line by Hernandezing, right? So this is an event where someone came in with a criminal history score below the dispositional line. And then after Hernandezing occurred, they were pushed from a stayed sentence, presumptive stay, to now a presumptive commit. And so we have 3 columns yet again. First, the offense name on the far left, then the percentage of Hernandez cases pushed over the dispositional line, and then the percentage of those cases pushed from criminal history score is 0, right? So they came in with a criminal history score of 0. This is not the same thing as a true 0. They could have had a misdemeanor record, or they could have had a 0.5 criminal history score point, something like that. But still thought it was useful information to know that they were going from 0 to over the dispositional line. So the percentage of Hernandez cases pushed over the dispositional line, the top offenses there were felon in possession, controlled substance 2, burglary 1, and aggravated robbery 2. And then similarly as the last slide where I had this format, I wanted to provide the highest percentage of cases that are being pushed over that dispositional line too. So here we have child sex abuse material, criminal sexual conduct 2, CSC 3, controlled substance 2, and assault 2.
I have a question.
Yes.
I don't understand the felon.
Yes, for sure. We had this conversation. You can continue your comment.
Say that, right?
Well, I had forgotten, so I'm glad you said something.
Yeah, so because I don't quite understand, you don't really have 0 criminal history because first of all, you're not a felon in possession of a firearm if you don't have that felony conviction, number 1. But number 2, there's a mandatory minimum that is a
Right.
commit. And so it's not getting pushed over dispositional line because the offense in and of itself is a commit. It isn't a state
Right.
sentence. So I don't understand that. I don't understand that data.
Yeah, sure. So you can still be pushed over the line by criminal history score if you have a mandatory minimum, right? It's still being pushed over the dispositional line where you're landing on the grid. It might not be changing your presumptive disposition, right? But if we are talking about, there's a committee for discussing mandatory minimums. I'm not sure like what the talks are specifically to this offense, but I thought it was still relevant to continue to keep in this presentation just for that knowledge sake of it being pushed. But you bring up, yeah, that's correct. That like the presumptive disposition for a felon with a gun is not changing by being pushed over that dispositional line. Any other questions on the slide? Great. And then our last one is talking about departures here, right? So these are pie charts of whether an offense received a departure, what type of departure that was, and yeah, whether it was mitigating or aggravating. So on the left, we have non-Hernandez presumptive commit cases, and on the right, we have Hernandez presumptive commit cases. And the stark difference here is between the light green and the dark blue on these two pie charts. So the overall takeaway from this slide is that Hernandez presumptive commits are receiving fewer mitigated dispositional departures than non-Hernandez presumptive commits. Any questions? And that's all we have for you. So now we've asked if you have any questions after each slide. So I'll continue to say any other questions. Professor Fraze.
Since you have breakdowns here between Hernandez and non-Hernandez cases, would it be possible, I don't know if Dr. Lascras, he actually ever did this, to go back into the recidivism data and see if there's a difference for people with the same criminal history, maybe control for offense 2, between people who have all true priors versus Hernandez priors?
Mm-hmm.
Would it be possible to do that, you think?
So we have a meeting tomorrow with the research team that we can
Okay.
definitely bring that up at. Thank you.
Any other questions? All right. Well, thank you so much. Really nice, interesting stuff you presented there. Now we'll ask Professor Reitz to join us, and he'll go through some additional work that he's done.
Okay, I'm gonna try.
Just need to turn off your own sound.
Okay, I think this might be better.
Yep, and you don't need to unmute because we'll give you the microphone.
Okay. Is my voice coming across on the?
Should be.
Yeah.
Okay, okay. Well, I'm very glad to be here today. In the comprehensive review over the last couple years, I felt personally that perhaps one of the most important issues we've studied and thought about that we've begun to think about is the Hernandez rule. It's very complicated. It has a very big impact on a lot of cases, and my sense is that it's going to take considerable study on the part of the commission to grapple with Hernandez and its various permutations and effects in different kinds of cases. Now, I just wanted to say that over the last year or so, with the really good research assistant at the law school, Emma Walsh-Alker, we've done a lot of work, at least preliminary work, trying to figure out how multiple counts of conviction are handled, not only in Minnesota in different scenarios, but in other guideline systems across the country and even abroad in England and elsewhere. Now, just to introduce the issue, it's already, I guess, been introduced. It's important to know that the Hernandez rule is not used in the vast majority of guideline systems in other states or in the federal system. The Robina Institute did a study of this about 10 years ago and found only one other state that used anything like the Hernandez rule for multiple counts of conviction among, I think, a total of 17 guideline states or so at the time. So this is decidedly a minority rule. And my sense from looking at Washington State, which is the other, quote, Hernandez state, is the criminal history rules work differently, and the effects of their version of Hernandez are muted compared to ours. We don't have projections, but I'm certain in my own mind that the Hernandez rule has a significant impact on Minnesota's prison population and rate, and almost certainly contributes to racial disparities that we see in Minnesota in prison admissions and rates. Large numbers of cases are affected. I've looked at quite a few. I have yet to come upon one in the reported cases that involves multiple criminal complaints as opposed to multiple counts in the same complaint, but we don't have data on that. We do know that at least in many Hernandez cases, the consequences of Hernandezing are to boost severity by quite a bit, okay, compared to non-Hernandezed, a non-Hernandez approach or what would happen in other jurisdictions. And Matt presented some data. He also did an earlier study on Hernandez and found, as he presented today, that more than 25% of all guideline sentences are Hernandezed. And across all of guideline sentences, 45% of the Hernandez cases cause the defendant's presumptive sentence to cross the dispositional line from presumptive stay to presumptive prison. And this is a pretty big deal. That's a lot of cases. Also, as Matt says, the frequency of use of Hernandez has been growing, and the number of current convictions in multi-count cases that are fed into the Hernandez rule has also been growing. So to the extent that there are concerns about the rule, those concerns seem to be getting larger and larger. Now, one preliminary question is who in the state of Minnesota has responsibility to reassess and perhaps adjust the Hernandez rule? The Minnesota Supreme Court has said over more than 4 decades that problems with Hernandez should be addressed by the guidelines commission. And I just include a string cite here, which no one can read right now, but that it collects a lot of those cases. Now, I'd like to give you some sense of the Hernandez rule in operation. There are many different scenarios, so it's hard to grasp or describe all of them. But when Hernandez applies, so the exceptions that Linda talked about aren't in place, the guidelines deal with the multiple counts of conviction through additive increases in the criminal history score for each extra count. And as we know, this has the tendency to move the cases from left to right across the guidelines grid. My research assistant and I have looked at multiple Hernandez scenarios. There are many different questions that arise out of these scenarios, but I'm just going to give you one illustration for those who aren't fully familiar of Hernandez at full reach in a multiple count case. And this is based on an actual Supreme Court case, State versus Bakken, that reached the Minnesota Supreme Court. As charged, the defendant was charged on seven different days over several months with downloading, viewing, and saving to his computer 7 separate pornographic images of minors engaged in sexual conduct. Each photograph depicted a different minor. So he was charged in the case with 7 counts of possession of pornographic work involving minors. On the sex offender grid, this is down near the bottom in severity level G, at least the offense of possession of child pornography. So the defendant had no prior convictions before this case, but treated as criminal history, each child pornography count received 1 criminal history point. And so what happens is for the first count, the defendant begins with a criminal history score of 0. With count 2, the criminal history score rises to 1, and so on, all the way to the 7th count, where the criminal history score for the defendant's sentencing was the highest that it gets on the guidelines grid, 6 or more. Okay. So under the Hernandez rule, the most serious count drives the sentence if we're talking about concurrent sentences, which are required under Hernandez. And the 7th count now has a presumptive prison term of 51 to 60 months, which goes all the way up to the statutory maximum for that crime. If we were to look at concurrent sentences without the Hernandez rule, all counts 1 through 7 with a criminal history score of 0 would have a presumptive sentence of state sentence of 15 months. Okay, so just thinking about what Hernandez has done to this case down towards the bottom of the sex offender grid is that it's taken the defendant with 7 counts from criminal history score 0 up to 6 or more. So that's how you get the from a relatively short probation term to somewhere between 4 or 5 years. Okay. Now, one question I think we need to ask is whether in a case like this or other cases that we could mention or study, does this operation of the rule further the guidelines goal of proportionality in sentence severity? If you look on the sex offender grid or also on the main grid, you can compare the sentence that was upheld in Bakken to where that would be for a first offense or even a second offense up higher on the sex offender grid. And that's what these arrows are indicating. In order to get a comparable presumptive sentence to Hernandez, you have to go up to severity level C with a criminal history score of 0 or 1. Now, looking at all the grids, the standard grid and the sex offender grid, it's possible to identify many types of offenses that would receive the same or lower presumptive sentences than in the Bakken case, or in the hypothetical, or the case that we've just been discussing, including first-degree manslaughter, second-degree manslaughter, criminal vehicular homicide, aggravated robbery, arson in the first degree, kidnapping if the victim's under 16, et cetera, et cetera. Okay, so this Bakken case with 7 counts of possession of child pornography has reached up into the zone or even higher than the zone of these many serious offenses. So one point I'd like to make in the commission's review of the Hernandez rule, it's very important to study a wide range of Hernandez scenarios, not just the single example. I've given the impact of Hernandez varies, and sometimes the sort of inexplicable effects of Hernandez depend on the exact kind of case scenario you're looking at. Now, one thing I'll just mention briefly is going back to the early 80s when the Hernandez rule came in. Studies of the first several years after Hernandez agree that prosecutorial practices changed almost right away to start charging more counts in multi-count cases. So this is from Richard Fraze's research through 1989, that for property offenses, the number of property offenses with a criminal history score of 4 or more doubled from 1981, when Hernandez was decided, to 1989, with the result that the percentage of presumptive prison sentences for property offenses more than doubled, from 7% to 17%. Another study commissioned by the National Institute of Justice involved extensive surveys with practitioners that noted that prosecutors had the power to charge multiple complaints and, quote, target the dispositional line. So there are enough counts to get across the dispositional line, or increase the period of confinement for states that were all cases that were already in the executed prison category. And that survey raised the question of whether this possible impact affected plea bargains in cases that were not maximally Hernandized. Now, the Minnesota Supreme Court itself has recognized that the rule is potentially subject to disparities based on prosecutorial discretion. Here's a quote from State versus Patel in the mid-1990s. One prosecutor could charge multiple counts as one way, where another might instead charge more counts to get this criminal history score up to the maximum. And here again, the court said, well, if there's a problem with this picture, it's up to the Sentencing Commission to address it. The other background concern I would make is that almost anything having to do with the criminal history score in Minnesota and in other guideline systems seems to be related to racial disparities in prison sentencing. So it's something that should be studied when we look at the Hernandez rule versus alternatives. In a classic 2009 study by Richard Fraze of racial disparities in Minnesota prison populations, he found that at the time, high criminal history scores accounted for about 2/3 of the black-white disparity in who received presumptive prison versus presumptive probation sentences. So criminal history is implicated, at least much of the time, in racial disparities across jurisdictions. Professor Fraze and colleagues updated some of that study with 4 jurisdictions and found somewhat similar effects, that half or more than half or close to the half of racial disparities in who gets sent to prison as opposed to not are coming from high criminal history scores. Now, There are concerns, obviously, with criminal history. It's been a focus of the comprehensive review for more than 2 years. But Hernandez magnifies whatever the effects of a criminal history score by extending it into the domain of many multiple count cases. Okay, so let me offer some comparative observations on how Minnesota compares to other jurisdictions on some key issues. A key consideration in Minnesota compared to other guideline states is that the Hernandez rule pushes significant numbers of presumptive sentences across the guidelines dispositional line. We know that from the data. Here's the 45% figure that I mentioned earlier. 45% of Hernandez cases go across the dispositional line. But this matters more in Minnesota than it does in most other guideline systems, because Minnesota's sequence from the guideline cell right to the probation side of the dispositional line, crossing one increment to the executed sentence side of the dispositional line, has what I call unusually high cliffs. And if you look at various parts of the grid from Minnesota, you'll see in some cases a case goes from a presumptive probation to a prison term of over 4 years, or all the way down, crossing the dispositional line always results in a presumptive term of at least 1 year or 2 years or 3 years. So these cliffs are more exaggerated than we see in other guideline systems. Indeed, Emma Walsh-Hawker and I in our research have yet to find any state guideline system with penalty consequences immediately from one side of the dispositional line to the other as severe as those in Minnesota. So the fact that Hernandez drives large numbers of these transitions is of unique concern in Minnesota, also different from other guideline states. It doesn't take much of a push in the criminal history score to move a case across the dispositional line. It takes one criminal history point in all portions of the grid to move across the the dispositional line in Minnesota. And you can get one criminal history point for offenses that are as low as severity level 3 on the guidelines grid. Okay, so relatively low seriousness prior offenses or Hernandez offenses can push you across that high cliff. At severity level 3, we're talking about things like theft over $5,000, check forgery, credit card fraud, computer theft above $2,500, repeat shoplifting. Okay, so the cliffs in the Minnesota guidelines combined with how the Hernandez rule is operating is kind of a double whammy that I think the commission will need to look into and assess. Now, if we look from other systems and just ideas that come out of approaches to multiple count cases, we have decades of research within discretionary sentencing systems of how trial judges tend to handle cases presenting multiple counts of current convictions at one sentencing. And again, there's a string cite here, but the research shows within the US and across national boundaries that judges who have broad discretion to sentence in multiple count states generally will always increase the severity of the total sentence for the multiple counts. But the increase of severity per each extra count in the multiple counts typically diminishes with larger and larger numbers of multiple counts. So in fact, this has been called in the literature the bulk discount in multiple count cases. That's not what the Hernandez rule does, but if there is some wisdom to be taken just from studies of judges with discretion, that's a data point. Now, in terms of policies and principles, probably the most intensive study of multiple count sentencing has been done in England and Wales, including Andrew Ashworth, the now retired professor from Oxford University who held the William Blackstone Chair for quite a few years. And one of the principles in England and Wales in multiple count cases is called the totality principle, and which actually has a couple different dimensions. But one is that multiple count sentences for a less serious offense, even a number of less serious offenses, should not be disproportionate to the punishment levels for a significantly more serious offense. So this is a principle of law in England, but as we saw in the Bakken illustration earlier, the totality principle used in England and in Wales doesn't seem to operate, at least in some Hernandez cases here. So just as a recommendation of what you may think about in reviewing the Hernandez rule, it's important to study the internal proportionality of Hernandez results with other sentences for much more serious cases, as we saw earlier. Okay. Also, in England and Wales, the totality principle includes a thought that multiple count sentences should not be so severe in an individual case that they're no longer justified by the purposes of sentencing for individuals. And one of the what's often quoted in the literature is that multiple count sentences should not be allowed to deliver a, quote, crushing sentence upon the defendant in that case. Now, as we noted earlier, the purpose of the Hernandez rule, as declared by the Supreme Court, is judicial economy, and to allow a court to deliver a sentence in multi-count cases that would be the same as though each of those counts had been brought in a separate proceeding by a prosecutor, resulting in separate sentences. So after decades of experience, the commission might choose to ask, is the original rationale for the Hernandez rule sufficient to justify the severity effects that we're seeing, at least in some cases? Also, does the rationale in multi-count cases really realistically reflect prosecutorial behavior or choices in how to proceed? So in its review, it's worth, as we did with criminal history in the last couple of years, it's always worth focusing on the question of whether this aspect of the guidelines serves the utilitarian and retributive purposes of the guidelines, apart from the sort of side purpose of judicial economy. Now, alternatives to the Hernandez rule, the most common one across the country is to impose a concurrent sentences, allowing the extra counts to be considered as aggravated factors for durational departures from the most serious count. Okay, that's quite different than what Hernandez does. Although in an earlier case, the Supreme Court of Minnesota recognized that, well, the sort of aggravated departure approach was one that could be open to prosecutors in Minnesota. This is, again, the case of State versus Patel, which said that, well, one option is to sentence the most serious count with aggravation for the multiple counts. Patel held that, however, a prosecutor can't do both. If the case proceeds in a Hernandez posture, then the multiple counts cannot also be treated as aggravating factors supporting a durational departure. Now, looking at other guideline systems, there are various formulas, including discretionary formulas for how additional counts might be scored to add increments of severity. Utah's formula in both concurrent and consecutive cases has a sort of numeric formula that for multiple counts, the main charge, the most serious charge, sets the baseline sentence, and then in addition to that sentence, additional duration of 10% of the recommended stay for each extra count be added to the baseline sentence. So an example for this is actually given in the Utah guidelines. Suppose you have an aggravated robbery count as your most serious count with a presumptive length of stay of 84 months, but you have an additional aggravated assault count with a recommendation of 20 months. Their formula would say, well, you add 10% of that 20-month to the 84 baseline sentence, so you get up to 86 months. Now, if the judge chooses to impose sentences concurrently in Utah, then the Sentencing Commission in Utah recommends a 40% increase for each additional count when consecutive sentences are imposed. So in the exact same example above, the additional aggravated assault count would add 8 months to the 84-month sentence. So this is just an example of a formulaic approach. But if you contrast the Utah's sort of aggravation approach with Hernandez, if you start with an 84 in the range of an 84-month sentence under the Minnesota guidelines, an aggravated assault count would add 1.5 or usually I think 2 points to the defendant's criminal history score. So you would be looking at a jump forward for an aggravated assault count in terms of years, not months under the Hernandez rule. If we get up to 2 extra counts and 3 extra counts, then those jumps get even bigger and bigger compared to the sort of durational aggravation approach. Now, a number of states, our research isn't yet thorough enough. We don't understand some state systems to know this, but a number of states take care to limit the effects of aggravated departures in multi-count cases to durational increases rather than moving someone across the line from probation to prison. One example is Maryland. Maryland has formulas for both concurrent and consecutive sentences in multiple count cases, which expand the guidelines ranges in some instances where there are multiple counts. Sometimes the ranges are just made concurrent, sometimes they're added together, but there is no mechanism in Maryland for multiple counts to move a case across the dispositional line. It's always going to be an expanded durational range. Okay, and Maryland treats consecutive sentences, the Maryland guidelines says consecutive sentences are appropriate only when necessary to accommodate the total duration of the sentence imposed under the guidelines formula. I think the federal system works similar. Okay. So in review, just having given a couple examples, the commission's review of Hernandez should include a study of the severity of consequences of Hernandez compared with alternative approaches to multiple count convictions in other guideline systems. In particular, this problem of crossing the dispositional line as frequently as we see in Minnesota is something worth comparing with other systems. Now, the last thing I'll raise is that there is an argument, the leading academic argument in defense of the Hernandez rule, as I understand it, raises the fear that cutting back or eliminating the Hernandez rule in Minnesota would result in greater numbers of consecutive sentences imposed by Minnesota judges, and that the severity consequences of that would be worse than or more severe than under the Hernandez rule. Okay, now, personally, I don't agree with this. Criticism guideline systems in Minnesota and elsewhere have pioneered a number of mechanisms to regulate and limit the severity of consecutive sentences. Minnesota already has a healthy set of rules on when consecutive sentences are presumptive or or permissive or presumptively not allowed unless there's a departure. Some states like Kansas and Alabama have adopted hard caps on the severity of consecutive sentences. And also it's possible, and in some jurisdictions, Maryland and Alabama, consecutive sentences can never cross the dispositional line. So to the extent that that's been frequently voiced objection, certainly worth thinking about, but Minnesota has been one of the pioneering states in addressing the consecutive versus concurrent issue in its guidelines. Perhaps the guidelines could do more, but it's another issue for the commission to consider. That objection is worth considering. Okay, I think that's it for my presentation. Hopefully I've left a little time for questions if there are any.
Questions from commission members?
I have a question.
Commissioner Ede.
Did you do any exercises looking at other state systems aside from the discretionary sentencing states to look at maybe comparable counts, comparable?
Yes.
Yes.
Yeah, we did a number of those, and we have yet to find a system that penalizes as heavily as the Hernandez rule. Okay. Now, there are some states that have, I don't know, at least within driving distance of the same severity increments across the dispositional line. No one has the same type of severity, but then those jurisdictions are not kind of Hernandez jurisdictions. So that would never occur in a multiple count case. That would require successive prosecutions in separate individual cases.
And then I guess my follow-up is, did your research presume the same thing as the data we saw earlier, that Hernandizing writ large includes both multiple complaint cases, multiple files that are being sentenced on the same day, and multiple counts in a single complaint?
No, we were only looking at multiple counts in a single complaint. And I would love to know what the data are on that question. But again, among the reported decisions, I have yet to run in Minnesota. I have yet to run into a multiple complaint case consolidated for sentencing. But that's an issue that I've been made more acutely aware of today. So it's something we can dive into with the commission's help.
I was just trying to compare. Your number is 45% of cases are Hernandized.
Right, that's the commission. 45% of all guidelines, 25% or more in recent years of all guidelines cases are Hernandized. And 45% of those cases that are Hernandized cross the dispositional line because of the Hernandez counting rules.
But that data was this data that includes the multiple.
Right, that's Matt's data from an earlier, he gave data sort of broken down by offenses today, but that was the sort of the entire guideline sentencing count.
Commissioner Castro.
How do we manage is probably the wrong word. How do we deal with the fact that a large part of this has to do with prosecutorial discretion on how they charge and how they settle cases?
Mm-hmm.
I mean, you have your example of the individual with the 7 pictures of child porn.
Right.
One jurisdiction that allowed them to plead to 2 pictures. In another jurisdiction, he might be required to plead to all 7.
You mean within the state of Minnesota?
Within the state of Minnesota. Yeah, and so, I mean, how do we manage that? I mean, that fundamentally to me is,
right.
I mean, seems what's unfair.
Yeah, well, the ability of the prosecutor's discretion to matter that much in a multi-count case is entirely dependent on the Hernandez rule. So if you didn't have a Hernandez rule, then concurrent sentences would not be increased with each count. So the question I would ask, or think that the commission needs to think about, is does the Hernandez rule magnify prosecutorial discretion in these types of cases, right? And in the Bakken case, I don't know when they searched his computer, for all I know, they found 50 images, but it only takes 7 to get up to the highest criminal history score. So Hernandez invites, if not encourages, that kind of thought process on the part of prosecutors that would not be there without the Hernandez rule, unless the prosecutor felt that it was worthwhile bringing a separate prosecution for count 1 in, early part of December, a separate prosecution for count 2 a week later, separate prosecution. That would be the way that a prosecutor's discretion could duplicate the Hernandez rule without Hernandez, but it would take a lot of it would take 7 separate proceedings to do that without Hernandez.
Commissioner Fraze.
I guess maybe a comment, it might be a question, and then a question. The question actually was triggered by Commissioner Castro's question. I take it about charging variations. The commission doesn't have, even in a sort of selective form, information on charges that were filed but then dropped, bargaining usually, because that's where this cashes out in terms of how many counts do you end up with. Well, depends how many you started with, so that's one discretionary decision, and then how many were dropped as part of the plea bargain. And I guess maybe the Supreme Court has that information, but it isn't integrated into our database, is my understanding. And I guess the other comment, just as long as I have the floor, was when we're talking about and I'm not quite sure I understand the distinction between all-in-one complaint versus multiple complaints, as long as they're all in this one sentencing hearing, as opposed to different judges, different hearings, even on the same day. My understanding is that, at least for data purposes, multiple cases against the same defendant get counted as one case if they're close enough in time. Is that right?
Can I have someone from the research team answer the question about how we handle that? Jill's going to come over.
Can you just repeat that again?
Somewhere years ago, I read in one of maybe it was in the 1984 3-year evaluation, that it said that, how do what counts as one case? And I remember reading that, if this defendant had multiple cases, I'm not sure they even had to be in the same court, but within 6 months or about the same time, it was considered to be one case. So it was usually they would be different complaints.
Right. Thank you. Regardless of if it's being charged on a single complaint or on multiple complaints.
Actually, what he's asking about is how you do the data piece of it.
Oh,
So talk
thank
about
you.
the rolling
Because
up.
that's how the only way we can look at it is the way we do our data.
Yes.
yeah,
Okay.
yeah.
Oh, thank you. Okay. Thank you for clarifying that. Yes, we would only count that. We count the most serious case for that defendant in a 1-month period of time in a single county. So if a defendant had a case in Hennepin County and also had a case in Ramsey County, we would count that person would be counted 2 times in our data before we collapse it. Now, when we have the data initially, we do look at, we have to compare each of those cases to see which is the most serious case. But then, yes, we only counted 1. Our data is person-based.
And I think, that it doesn't affect sentencing. What it affects is how our data is reported. And it's just a decision that was made a long time ago, way before my time, about how the commission would count cases when a person might have, a 4-count case, are we, what are we counting? We have all the counts. Are we counting all 4 counts in our data? Are we counting the most serious count in our data? If they are getting sentenced really close in time together with multiple counts, how are they doing it? So what they're talking about is collapsing the cases so that we can get a cleaner picture of what the sentences were across the state.
But only collapsing within a count.
Right. Yep, that's correct.
Commissioner Ladd.
So, just because prosecutorial discretion was invoked, I think I want to say something here. I think the other thing that gets missed here is, just from a practical perspective, very rare, if not ever, are you going to find a CSAM case where there's one image. We're talking hundreds and thousands. And so where discretion comes into play is how many counts am I going to charge? So one of the things that we look at is we look at the number of victims. We look for periods of time. We might have 100 downloads on one day, but you've got a period of 4 years of images and horrific, videos. And so I think that if you end up with a 10-count complaint, when you're looking at that kind of information, there's a lot that goes into that decision making before those charges even hit that charging document. Does it make sense for me to charge out a defendant with 15 complaints because on 15 different days he had hundreds of images with multiple victims? Could do that, but that goes to the issue of the judicial economy piece. It's the same defendant, the same kind of behavior, multiple time periods, multiple victims. And I think your little graph that you had with the arrow on putting somebody over the dispositional line, and I think was severity level C maybe on the grid. Part of the issue is the elements of some of those offenses actually talk about periods of time, like if you're a victim who is sexually abused over a multiple period of time, that's an element. So that's baked into the element of the crime. But if you are talking about CSAM material, one image, that's it. And so treating them the same concurrently, there's a lot of things that kind of go into that. So I think that's really going to be part of our discussion. I think we're going to have is the kinds of offenses that we're talking about here, that they come into play, that you see them a lot. There's a lot of rationality that goes into that decision making about why that happens. Because again, when you've got someone who has hundreds, if not thousands of images over a period of time, they finally got caught, what is the appropriate consequence for that behavior for all of those victims? That's the prosecutor's discretion that goes into the actual charging document.
Other comments, questions? Oh, Commissioner Mueller.
Thank you, Commissioner Ladd. I was actually going to call you out to have you make a couple of comments on that. And I also, part of me feels like using CSAM as an example in this case, as we're talking about it, it's a little tough for me because I'm actually okay with what happened in that case. But I think still have a lot of questions with how any change we make, what kind of permanent change I would make in the system versus just a change in prosecutorial discretion moving forward in these cases.
Can you elaborate on what you mean by that? I'm actually not sure.
Well, I just wonder if, and maybe I'm just naive in this piece, I just wonder if the case that Commissioner Ladd is talking about with hundreds of images in a CSAM case might just be spread along, broken up more cases. If we're looking at judicial efficiency, that is going to be taken into account without this Hernandizing. Does that seem like a change in where maybe prosecutors might charge differently without this rule in place?
Yeah, probably. That could very well be, I would assume. Yeah.
Well, I don't speak for every prosecutor, but I do think that obviously would be part of the factoring and of the many things that prosecutors go into making that charging decision.
Mm-hmm. Yeah. Other comments or questions?
Yeah, I should say that I hope it won't be too distracting that the one illustration I gave today was the child pornography case, because there are lots of different Hernandez scenarios that one could look at, including what Professor Fraze found in the late 90s, that property offenders were being pushed across the dispositional line and larger numbers. So it's, you know, Hernandez, maybe I should use the word global, but Hernandez covers a lot of different case categories. And we're just on day one of, I think, the commission's review of the Hernandez rule. And whatever the commission does, I think it's going to be important to study many different types of cases and scenarios.
All right.
Can I ask one other question?
Yeah, Commissioner Reed.
If there is gonna be a look at the data in more detail, is it possible to look at demographic data specifically as it relates to Hernandez sentences? So that can be better understood? Because I take the point that in Professor Grace's research, criminal history generally, the driver of disparities, but I just wonder if it might be helpful to see that specifically in Hernandez context. The other is if the data could look at the mandatory minimum issue that Commissioner Ladd raised, like how much in terms of the dispositional line question, whether that should be considered a true push over it.
All right. Yeah, I'm sure that those are both things that we can look at.
Right. With respect to the 2025 amendments, the commission was able to generate racial impact projections for various criminal history reforms that were approved last year. So I would hope, I mean, Hernandez is so complicated, I'm sure the data are complicated, but I would hope that something similar will be done here.
Yeah. Commissioner Keith.
Having this conversation, it is to look at disparities and think about equity for folks that are being sentenced using the guidelines, while also balancing victim like justice. Yes. So another question is like, I feel like part of what I heard is that Minnesota has more strict or more severe sentencing guidelines overall. So am I not hearing that correctly? I'm always like walking around the topic, not quite hitting the mark. Eventually, it takes like 2 years, I'll get there. But if that is correct, I guess something else I'd be curious about is like comparing us to other states and really seeing like, is there movement that we can make to balance things while we're also considering. And if I'm wrong about that, then just ignore me.
Yeah, no, we can definitely compare policies and, think about how those policies might have different impacts. It's hard to compare actual sentences from one state to another because there's so many variables, but we can definitely compare policies. And I would say that, in addition to looking at disparities, balancing that with the victim impact, it's our responsibility to look at proportionality in sentencing as well, right? Just to look at, whether this sentence is hitting the mark in the right place based on other factors like the offense severity, the history of the offenders, or of the individuals. So those are things we always take into account. But yes, disparity, victim input, absolutely. All right, any other discussion on this? Great. Thank you so much for joining us today. Appreciate it. We will move on then to the next item on the agenda, which I've lost. Oh, here it is the restructuring of the guidelines, and Director Wrights is going.
Good afternoon. Can you hear me?
We can.
All right. Well, first of all, I'd like to apologize for not being there in person. I think in about 11 and a half years of service to the commission, I think this is the first time outside of the pandemic where I was actually not present in person at a commission meeting. But I'd like to talk to you about one possible project that we might engage in this year, which is restructuring the sentencing guidelines. And actually, I'm not sure if everybody's aware of this, but the chair is my predecessor. So 11 and a half years ago, she was the executive director of the Sentencing Guidelines Commission, and she undertook a project that was designed not to make any substantive changes to the sentencing guidelines, but simply to reword it, get rid of the Roman numerals, and make it easier to understand. But this is really a little bit broader scope, which is restructuring the sentencing guidelines, and really the impetus came from a number of different stakeholder groups when we did our stakeholder engagement earlier in the comprehensive review, and there was a cry to simplify the sentencing guidelines. The people appreciated the simplicity of the grids. The grids are pretty easy to use, to understand as a practitioner, and particularly to communicate with, say, if you're a defense attorney, to communicate with your client, or if you're a prosecutor, to communicate with your victim. Just sort of expectation setting. Here's what the sentencing guidelines are looking at in this case. So the simplicity of the grids are appreciated, but the general complexity of the guidelines was not appreciated. And just going through Linda's presentation, you kind of get an idea. That's just one policy, Hernandizing it, and you got exceptions to exceptions, and it can get pretty confusing. But one specific suggestion, and I looked through the materials, I could not find this written down anywhere, but I recall hearing this. Perhaps some of you do as well. There was a suggestion to organize the guidelines like Minnesota statutes. I think it was from our probation officer, I'm recalling correctly. But the idea being, we understand how Minnesota statutes are organized. We have to deal with them all the time. If we're a practitioner of the guidelines, then we're certainly a practitioner of Minnesota statutes. We just have to be. So why have a completely different organizational system? So I kind of ran with that in sort of some of the proposed solutions. So what I'm going to do is go through two problems with the sentencing guidelines, two big problems with the sentencing guidelines. And then the third slide will be just a ton of problems with the sentencing guidelines, little ones, but and then propose solutions. Now, obviously, this is going to go through a committee process, and the committee will end up with the solutions. And I'm not trying to step on any toes by proposing a solution. It's simply, the old saying, it's easier to drive a moving car. So the idea is we get something out there for the committee to look at and see what they think. So the first problem, I think, is really the guidelines outline structure. And what I mean by an outline structure, it's like 1A, it's just a hierarchical structure that goes farther and farther down. And the problem is you don't necessarily know where you are in the hierarchy. You kind of have to remember, that this is section 2 or whatever 2, just number 2, that started several pages ago. You kind of have to remember that. So the original 1980 guidelines started that hierarchical outline structure, but the guidelines were only 18 pages. That was before they put the commentary in the guidelines at that time, but the guidelines were significantly much more brief. So you could sort of see the outline. You might have to flip back a page or two, but you could generally see where you were in the outline, being that the guidelines were only 18 pages long. Even then, though, you could get lost in section 2, which is still the biggest section. And I say section, that's kind of one of the problems. I don't know what 2 is. I don't know if it's a section or a guideline or what it is. Part 2, I don't know. But anyway, whatever Roman numeral 2 represents, it was pretty long even back then, and you could get lost. It was 7 of those 18 pages. So definitely a plurality. Today, however, with the commentary and with the appendices, which technically are not part of the sentencing guidelines, but the commission deems them to be useful to practitioners, so they're in there. The guidelines are 149 pages long, and section 2, which is still determining presumptive sentences, is now a Arabic numeral instead of a Roman numeral. That was one of the changes with the guidelines rewrite over a decade now. What was that? 2011? Is that when the guidelines rewrite was?
Somewhere in there, 2012. I don't know. 2010.
So that was one of the changes made. Then it switched from Roman numerals to Arabic numerals, but it's now 65 pages long, and it's very easy to get lost in the outline hierarchy. Now we have Staff has added sort of some context clues on the bottom of each page now, so you can sort of maybe hopefully not get quite so lost. But it is essentially an inherent defect in the guidelines hierarchy. So again, we're going to talk about a suggested solution now. There's probably multiple solutions here, but this is just one that staff is suggesting. There's probably a lot of ways to do this, but the suggestion is to adopt the statutory decimal format, and that's really sort of what that practitioner had suggested, at least as far as I recall, back during the stakeholder engagement process. So Minnesota statutes are organized by chapters and sections, so it's easy to find, it's easy to cross-reference, it's easy to know where you are, and it's really easy to label everything. And it's done so decimally, so it's a decimal numbering format as opposed to an outline hierarchical format. So if you have a 609.02 and you have a 609.03, and you want to stick another section in between them, you can call it 609.025. Because if you were to number them, organize, arrange them decimally, 609.02 is smaller than 609.025, and 609.03 is larger than 609.025. So 609.025 fits in the middle there. So you can, so there's room for expansion and so forth, and it's pretty easy to understand where you are. So the suggestion then is to adopt this familiar, less confusing format. And, oh, by the way, just completely adopt the reviser's standard style manual. So the reviser has a standard style manual. Sometimes the guideline style is a little bit inconsistent. I know this is a little bit nitnoid, but it is, I think, helpful to practitioners to feel like what they're looking at is familiar and they understand how it works. And it's probably would be helpful for courts interpreting the guidelines as well. One significant change from that's being suggested, that I'm suggesting here, is instead of calling each section a section, you call it a guideline. And there have been court cases that refer to different policy chunks as guidelines, but it's really not clear what a guideline is in the sentencing guidelines. So the idea is that each section, if you will, would be a guideline. So this snippet here that's shown on the right side of my screen is section, I'll call it section because I don't really know what it's called, but maybe it's guideline, but section 2B5 of the current guidelines. So that's in the hierarchical order. It's under 2, and then it's under B, and then it's under 5. It just starts off saying 5. It doesn't say 2B5. You have to kind of figure that out, but it starts off with the number 5, and you have to know that you're in 2B5. But this would be called guideline 2.24 as it's renumbered to sort of conform to the reviser's standard style manual. So that's one benefit is this is called 2.24, and if you look at the bottom here, you'll see the cross references to other guidelines. So it's really easy to cross reference. It's guidelines 2.2 to 2.23. So it just makes it easier to understand what you're doing. And then the other part is the parts within the guideline, or which is like a statutory section, are also clear and standard. So these are subdivisions within a guideline, and you can cross-reference other subdivisions within that. So it just kind of makes a standard statutory decimal format that Minnesota practitioners certainly will be quite used to. But again, as I said, that's one solution. There are other solutions, but we've gone ahead and started drafting something so that you can, whoever's on the committee will have something to work with rather than just a blank slate. The second problem, and I hope I'm not being disrespectful here, but I'm calling it a mess of mandatory minimums and modifiers. And the problems are that policies that modify the grid disposition and policies that modify the grid duration, or sometimes they modify both the disposition and the duration, they're called mandatory minimums and they're called modifiers. They're squirreled away in various parts of section 2C, 2E, and 2G. They're not continuous. It's pretty hard to know how they interact with each other. And it's hard to find them. Again, as I said, the interplay between the different policies and between consecutive sentencing policy is unclear. Sometimes they're written as if that's the only possible modifier that could exist. So you're not sure what would happen if another modifier were in play, and there's quite a bit of repetition. And there's a sort of a statutory compliance problem too, because our charter statute requires the commission to come up with a presumptive sentence and then a permissive duration of 15% above the presumptive sentence and 20% below. Sorry, 15% below and 20% above the presumptive sentence, and that if you do the math in some of these modifiers, you actually end up coming up with a range that doesn't really follow that statutory requirement. So the staff suggested solutions are to organize the mandatory minimums and modifiers in a logical order at the end of chapter 2, provide a clear order of operations, meaning that you'll understand exactly how they interplay with each other, and ensure that the durations and ranges comply with the law. And then we get to the potpourri of other problems and solutions. So, and by the way, I'm perfectly happy to stop at any point and answer any questions. Yes.
Commissioner Lett.
So I guess it's either maybe to Chair Mitchell. So when this got restructured the last time, I thought you said around 2010-ish, 2011 with different restructuring. Was this structure, like the statutes, was that discussed at all? I was just wondering if there was any issues with sort of the restructuring last time, if there were any, for lack of a better word, pitfalls or some pushback or some tension that you landed where you did with how it currently looks versus like moving to this, because this seems like it makes a lot of sense, but I'm just curious what that discussion looked like and sort of how you landed there as opposed to somewhere else.
That discussion was the staff roping me into a very long and arduous process. No, I'm just kidding. At the time, the bigger problem was that there was a lot of guidelines that were really unclear and like just had been sort of tacked on over the years, and so not written consistently, kind of hard to understand. We needed to sort of simplify some of the language and make it more plain language. So we were really focused on that problem at that time. And that was, we went through like every word of every guideline and didn't even think about structure at that point.
Thank you.
And it was the intent at that time not to change any policy. And I'm being a little bit more forward here. And sometimes policies, like, if the policy doesn't provide for the statutory 15% down, 20% up, maybe we should change the policy. So this is a little bit less modest of a goal here, to actually restructure the guidelines. So going ahead with the potpourri of other problems. So the first one is that offender is an impersonal term, and that's been discussed in the past. I think it was brought to our attention, I can just remember, in January of 2020. And since that time, we've tried to avoid the use of the term offender in our reports as much as possible. It's hard to do because we still have the sex offender grade and the drug offender grade, so it's hard to refer to those grades without using the term offender. But the goal in our writing it has been to replace the term with personal language where feasible, and that includes in draft guidelines changes. We've tried to replace the term offender with the person being sentenced or something like that. The rules about how the guidelines apply are scattered. So there are, and by the way, not always completely right. Like there's a rule that says the guidelines don't apply to first degree murder because it's a life sentence. Well, first degree murder is not the only life sentence in Minnesota. So why only limit it to that? But it's also like that rule and rules about applying to juveniles and rules about which edition of the guidelines to use. Those are all conceptually the same. They all have to do with the scope of the sentencing guidelines. Why not just consolidate all the rules and put them at the front of the guidelines, which is really where scope rules belong. There are some inconsistencies with recent Supreme Court cases. So the guidelines have been either, well, at least clarified, let's put it that way, by Supreme Court cases, or actually the guidelines just flat out aren't correct anymore after some Supreme Court cases. And so the the proposal is to incorporate the cases called Kirby, Scoville, and Strobel into the sentencing guidelines. There's this big presumptive sentence chapter that we've talked about. Well, it would be called a chapter under the new proposal, but the presumptive sentence chapter has some unrelated topics in it. So the idea is that we at least relocate departures and conditional release into other chapters. Now, we had some discussion with staff when I brought this up about consecutive sentencing. Well, consecutive sentencing really is related to presumptive sentences. So maybe consecutive sentencing should stay in the big presumptive sentence chapter, but try to get, I mean, departures clearly don't belong in the presumptive sentence chapter. They're the opposite of presumptive sentences. So we should, make that chapter as smaller to the extent we can. Theft severity level rules can be very confusing. And I'll just leave it at that, but the proposal is to create new guidelines with clear rules, a new guideline with clear rules. There's some policy language that's only found in the commentary. And that should not be. The commentary is not policy. The appellate courts have made that very clear to us. We should not, like the severity level that applies to permanent theft of a motor vehicle, the cross-reference in 5B is to comment, and it really should be to the guidelines policy. So the goal is to promote those comments to guidelines text. Treatment of prior stays of imposition is only implied. This is also related to the previous rule that it's pretty clear. The treatment of prior stays of imposition is pretty clear in the commentary, but it's only implied in the guidelines themselves. So the solution proposed is to make the currently understood policy explicit. It's a challenge, and this is really a staff challenge, but it's not just, oh, poor staff, we got so much work to do. It's really a risk of error is what it is. So it's a big deal. It's a challenge to maintain the ranking tables as they're currently set up. So every time we make changes, there's a possibility of risk because a lot of it is manually done. And so the idea is to automate the table design and eliminate footnotes. So that should help there. The just naming, we're getting pretty picky here, but there are inconsistent or unclear offense names. Some of the offense names don't actually state an offense. And the application is to make the offense names consistent where, it could fit in the blank of a sentence, you are charged with blank, for example, because some of the offense names just don't do that. They're just nouns. And so make the offense names consistent and apply the revised style. And then finally, the history of changes is hard to research. And if you're familiar with Minnesota statutes, you know that at the bottom of each statute, the reviser puts in a history of all the changes that have been made to that statute. And the idea is that we'd start a change history section for each guideline. Now, I'm not saying that we will have the time or energy to go back to the beginning of, to 1980 and put all the changes that have ever been made to this particular policy in at that time, but at least we'd start it going forward. And maybe at some point we would fill it in, historically speaking, but at least going forward, we would have a consistent change history section for each guideline. So that's all I've got on that, Madam Chair.
Questions about that? Commissioner Ladd?
So are we thinking that this is a this year thing?
Yeah, Director Wrights has actually done an initial draft already. So what I would anticipate doing is appointing a committee to work through that draft with him to make sure that everything is something that we could support.
I just note that I don't know if it was our last meeting or maybe the meeting before when you talked about our accelerated timeline because of trying to get some things accomplished before December, really. So I just didn't know if that was sort of part of the plate of things that we were going to try to put on our list to do in 2026.
Yeah, it was. Yeah. And
Madam Chair, if I may.
well, no, I have to make a funny first, because Vice Chair Larkin had originally offered to lead this group. And then she left, so.
Well, I don't know that charge then.
That's what I was
Yeah.
thinking. What were you gonna say, Director Wrights?
Well, I'm just the draft that I did last year, it had I guess three things that need to be changed about it. One is it didn't have a good, it was not clear what the changes were. So I'm trying to rewrite it in such a way that you can easily see with markup text, where it's crossed out and underlined what the actual changes are to the guidelines. That's something that was missing from that, and that's something that the steering committee brought to my attention. It's a good criticism, and it does need to be changed because you need to be able to see what the changes are. The second is obviously the guidelines have changed since the draft I was working on last year. And third, the draft I did last year didn't do anything with the commentary, and that really needs to happen. So I'm still trying to make those changes to the draft that I made last year, but should have those done. I hope this month.
Yeah, so the steering committee had a chance to look at the prior version of the draft last year, and generally we liked it. But there were some substantive changes that were made as a result of just kind of the reorganization that he made. He found places where rules from two different places could be consolidated into one place, and that just got to be more than we could deal with at that time. So, so a couple of those changes actually came forward and made it into the steering committee package. The rule about how DWI counting is an example of that, where that was in comments, rules, a couple different places, and he consolidated all of that into one new guideline that is clearer. So, we saw the value in the work that he was doing, but it was more than we could do at the time. So that turned into a this year thing instead of last year thing. Commissioner Castro.
Thank you, Madam Chair. This might be unrelated, but I think it's somewhat related. What's the policy decision behind having unranked offenses?
Well, the way that it's described in the guidelines themselves is that those are typically offenses where it's difficult to rank because there might be multiple factors, or it's cases that have very few prosecutions, and so it's also difficult to rank from that perspective. So that doesn't mean that we can't revisit the things that are unranked. I mean, we definitely can. I'm thinking of don't we have like a RICO type violation in the law that's not ranked right now? And that's because the underlying offense really sets the mark for where we might put that, right? So it's things like that, I think, that tend to be unranked. Are there unranked offenses that you're concerned about that you'd like to work on?
No, it doesn't make sense to me why we would have unranked offenses regardless how many times they've been charged. I guess they can be easily weighed against current ranked offenses.
I mean, one example is if the legislature creates, and maybe I shouldn't say this because the commission has ranked some of these, but if the legislature creates a crime where the harm is death or great bodily harm, if you disclose information on a public official and it results in death or great bodily harm, well, that's quite a spread there, in terms of harm, death. I'm not trying to discount the gravity of great bodily harm, but death is significantly more serious than great bodily harm. So how do you rank a typical offense there where, is the typical offense death or is the typical offense great bodily harm? So that's an example of a crime that just has such a wide range of possible severity as it's committed that it's really hard to rank that. It presents a ranking problem for sure. And sometimes the commission just avoids those ranking problems by leaving it up to the individual judge, by leaving it unranked.
But if there are ever things that you think we should revisit, bring them forward, and we will. Because that's definitely part of our responsibility, is to make sure. I mean, if we're getting enough information that we feel that we really could rank something that's currently unranked, then we should do it.
And we do every year publish a report on unranked offenses, and it's really interesting. I think if you're interested at all in unranked offenses and why they're unranked, you know, you can get a look at them. The biggest one is aiding an offender accomplice after the fact, and that's an example of an offense that can, you know, it really vary on. I mean, for starters, what was the offense that was aided? You know, and then it goes from there.
All right, so closing out just the restructured topic, the next item on the agenda is committee appointments. And so we have two areas here where we had talked about having a committee. So if I kind of work backwards, the first one was the restructuring the guidelines project. And at our last meeting, the people that were interested in that were Commissioner Castro, Commissioner Middlebrook, Commissioner Eid, and Commissioner Fraze. If you are all still interested in that, then I would like to appoint you to work with Director Wrights on that project. Does that sound good? All right. And then the other subcommittee was this Hernandezing issue. And we unfortunately have more people interested than I can appoint because we have a quorum issue. So we need our committees. Subcommittees are typically below quorum. So the people that I would like to appoint to that committee are myself, Commissioner Middlebrook, Commissioner Moore, Commissioner Ladd, Commissioner Eid, if you want to do both. If you don't, just say so. And Commissioner Fraze, who also did want to do both. How does that work for people? Okay. All right, so those will be our two subcommittees. And then we will, sorry, I didn't have an opportunity to talk to staff about timing. Last time we shortened our main commission meetings for a few months to allow some time for subcommittees to take some of that time. And we didn't have a chance to talk about that, but I think we might actually have a few months here where there's not going to be as much on the main agenda where we could do that for some of these meetings. So stay tuned and we will potentially look at shortening the overall meeting to allow for some subcommittee time, taking into account that we have some people on both, so we have to manage that too.
Did we, Madam Chair, I don't remember when we were doing this. Did we also start at 1 o'clock as opposed to 1:30 on those ones that we were meeting before the actual meeting? So we came in earlier? Noon?
The
12:30?
yeah, the
Okay.
subcommittee came in a little earlier and the commission came in later.
Okay,
Yeah,
gotcha.
yeah. So it won't be for the commission members. We won't go outside of this this time frame, this 1:30 to 4 time frame. So like if anything, we might meet at one end or the other at that time. We won't go outside of that time. So you should already have these times on your calendar. That's my point. And it shouldn't add anything there. Okay. Next item is vacancy in the position of vice chair. And so today is not the day to vote, but today is the day for me to put everyone on notice that we do have a vacancy in our vice chair. And so I would like people to start thinking about whether you might be interested in serving as vice chair, who you're interested in having serve as vice chair. And we will put that on the agenda for March and we'll have a vote in March. So be ready with a nomination and a vote for who that vice chair should be. Any questions about that? And I will just say, I should say something. Vice chair, sort of how that works, how it's worked with as long as I've been chair is, generally the vice chair assists in sort of planning out what some of the meeting content is going to be. The director often will start the ball rolling by sending like, these are the things that I hear that you want to work on next. And so here's a potential agenda for next time. Is that in line with what you want? And then, I'll give feedback. Sometimes I'll confer with the vice chair about some of the direction that we might do. We give feedback. We might give some feedback on some of the materials for meetings and things like that. So there is a little bit of work behind the scenes for vice chair. And then if I'm unable to be here, the vice chair would also chair the meeting. So that would be the other responsibility of the vice chair. So just think about that and we'll take care of that election next time. And that takes us to item 8. So back to you, Nate, for the executive director's report.
Thank you, Madam Chair. The legislative session starts on Tuesday. We've the chair and I have been in contact with 2 of the 3 chairs right now. As you may recall, the Senate is chaired by one individual. The Senate Crime Committee is chaired by one individual, and that's Senator Latz. The House is co-chaired by 2 individuals. That's Representative Mueller and Representative Novotny. And so we've met with 2 of those 3 individuals. Unfortunately, my Florida vacation schedule and Representative Novotny's Florida vacation schedule, I'm surprised we didn't see each other in the airport. Let's put it that way. So there's just this huge amount of time where we could not meet, and hopefully we'll get it going soon. But it's been impressed upon us how compressed the schedule is for particularly for the House. So basically there's obviously a lot of interesting issues that have come up that have something to do with the public safety agenda since the legislature was last in session, and each party will have the gavel 5 or 6 times before deadlines start approaching. So that's a very, very short session for some of the magnitude of some of these issues. So it's quite possible that our legislative recommendations will get put off to the side, but we hope not. And we're hoping that perhaps the Senate, which has more time since they don't have to share the gavel, will perhaps come to the rescue and take up our legislative agenda. But that remains to be seen, and we'll keep you in touch as the session goes along. That concludes my report, Madam Chair.
All right. Well, and that almost concludes the agenda. We're down to public input.
All right, members of the public, if anybody's online and you would like to make a statement, you should all be able to raise your hands. It looks like you're all, well, I guess I don't know, but if you should be able to raise your hand if you tap to now. That's great. I see one person was raising their hand, so we have at least one member of the public online. And likewise, if there are any members of the public in the room, please let the chair know at this time. So, Madam Chair, one member of the public online does wish to make a statement.
Okay, so it looks like that's Katie McCormick. So do you want to unmute her?
Certainly. All right, Ms. McCormick, you are unmuted and you're now talking to the Minnesota Sentencing Guidelines.
Perfect. So my name's Katie McCormick and I'm a person of lived experience. Can you guys hear me okay?
We can, thank you.
Okay. So I'm just going to read, I wrote some stuff that I just kind of wanted to express with you guys today. So I'm here today because I believe deeply in this mission of this commission, and because I've lived the consequence of what happens when our sentencing guidelines fail to account for the full truth of a person's life, circumstances, and potential. 10 years ago, I was sentenced to 41 months in prison for my first felony offense. On paper, the charge was burglary, but the reality of what happened and the context surrounding it tells a very different story. At the time, I was struggling with my mental health issues, a substance use disorder. I was living in a home that had been raided for methamphetamines just 24 hours before my arrest. The person listed as a victim in my case was someone who was using drugs with me. He admitted in court that I lived in that home. He admitted he had stolen my belongings, and my actions were a response to that. Unfortunately, the possession that I took from him was a firearm. I did not take that firearm to use it, not to threaten anyone, but to pressure him to return what was mine. And I'm not excusing my actions by any means by saying any of this, but I was very honest with the police, and I told them we had argued and that he had asked me to leave a few days prior. And that later I used my house key to get back in the house when that individual was arrested during a police raid. Because of that honesty, I was charged with burglary. And even though this entire situation was rooted in addiction, instability, and untreated mental health issues, none of that was considered at sentencing. The guidelines treated the offense, not the person. They treated the moment and not the circumstances that led to it. I served 41 months for a crime that would have never taken place had I been sober. I was a first-time felon, but the guidelines did not allow room for nuance. They did not allow room for context, they did allow room for context, for crisis, and for the reality of addiction. In preparing for today, I submitted 3 cases for this commission, but I got it in late, so it'll be for the next commission on March 12th. Each involves a first-degree burglary. In all 3, the defendants either received a probation, state of adjudication, or local jail time under 90 days. I'm not sharing these to compare myself to others, but to show the inconsistency. When the guidelines are applied rigidly, people with higher risk conduct can really receive lighter outcomes than someone like me whose offense was rooted in addiction and instability. These cases illustrate exactly why individualized sentencing does matter. Since my release, I've rebuilt my life. I'm now a certified peer recovery specialist. I work every day with people who are trying to break the same cycles I once lived in. I serve on the Crow Wing County Restorative Practices Committee, where the local officials appointed me as chair. I give back to my community, and I've been formally pardoned by the state of Minnesota on December 17th. But even with all of that, the truth remains. My sentence shaped the course of my life in ways that could have been avoided if the guidelines allowed for a more individualized, holistic approach. Sentencing is one of the most powerful moments in a criminal legal system. It can either set a person on a path toward healing, accountability, and change, or it can deepen harm and disconnect. When guidelines don't account for the human being standing in front of the court, we risk creating outcomes that are neither fair nor effective. I'm not here today to criticize this commission. I'm here because I want to contribute and I want to help strengthen a system that has the power to change or break someone's life. My lived experience, my professional work in recovery and restorative practices, and the documentation I've gathered all point to the same truth that we can do better, and Minnesota's capable of leading that change. And I would be honored to be more involved with this commission's work, and I would welcome the opportunity to share the materials I've collected to offer insight from both sides of the system and to support efforts that ensure our guidelines reflect fairness, consistency, and the belief that people are more than their worst mistakes. Thank you. So yeah, I just kind of want to share some of that with you because I do see there's inconsistencies, and after I got that pardon, my next mission would be to become more involved with something that's near and dear to my heart, which would be this commission, because I do feel that there's flaws and cracks that need to be changed. Yeah.
Well, thank you very much. I appreciate you sharing your story with us today, and congratulations on your pardon. That's pretty extraordinary. I'm pleased that you were able to achieve that. It sounds like you've really done a lot since that day that you were sentenced, and I just really appreciate hearing the story. You are certainly welcome to send your materials in, and we'll take a look at them.
Mm-hmm. Yeah, no, I mean, I think it's important that somebody with lived experience is more is into this kind of stuff and a part of this. And I'm not so much as on one side of things. I look at it from both sides. I see the duties of the Sentencing Guideline Commission, but I also see 41 months was taken from my life, and it didn't need to happen. It really hurts my feelings when I see predatory offenses get a slap on the wrist or state adjudications. Like, it's insulting to me that our state is so lenient and towards crimes like that. And like my first felony ever, I was given a 41-month sentence, $100 fine, which a speeding ticket costs more, and then a year of supervised probation or parole. But I probably would have succeeded a long time ago in probably would have got this pardon a long time ago if I was even given 1 year of prison and 3 years of supervised probation parole. So it's just, there's just some inconsistencies. And I do a lot of work with restorative justice and restorative practice, and I've been to the Fargo Restorative Justice conventions, and they don't have sentencing guidelines. I'm not saying that that's perfect, because they have their flaws as well, but there's just got to be a way to look at the person and be able to take in what's on the discovery and not say, oh, this is the charge, we don't care the circumstance or what happened. Like, it's just black and white. Like, this is an area where it's somebody's life, and there should be a little bit of gray area. So.
All right. Well, thank you. I appreciate
Thank you
you
for
coming
having me.
today.
Yes, thank you.
Was there anybody else who wanted to make a public comment today? I don't think so. Right, I think the answer is no. So then that's the end of our agenda. Thanks everyone for your attention today. And I know that these were some little bit more complicated issues and a little detail oriented today. But this is also what we do here on the commission. We will, like I said, we'll get the subcommittee work going. We'll figure out the schedule for March, and if it changes, we'll let you know. But otherwise, today, if there's no objection, I will go ahead and adjourn the meeting, and we'll see you again in March. Thank you.
For those on the Hernandizing committee, I have 2 copies of a book called Sentencing Multiple Crimes, recommended by our director.
Yeah.